Greetings, dear listeners. This is Jonah Goldberg, host of the Remnant Podcast, brought to you by the Dispatch and Dispatch Media. There are people who think that, like Sarah and David, they are the official pontifical oracular authority on all things legal here at the Dispatch, and I just want to say that is a passel of lies. I cede no such territory to them. And so in a brilliant counter move, I've decided to invite, and also part of my longstanding, totally unplanned policy of like getting various department heads, and sub-department heads, on here from AEI. I've got my friend and colleague, Adam White, to come on here and talk, all sorts of law type stuff. You run the Constitutional Center, whatchamacallit thing at the American Enterprise Institute, correct?
Indeed, I do. Thanks for inviting me, Jonah.
But you are you share with me. We are both bannermen of House Levin. So
yeah, we're serfs working the fields that he owns, but he allows me to oversee a project called the Center for American Constitutional Government.
So there you go. So I don't know if you know this, but I whenever Yuval comes up, I always kind of chuckle a little bit because, his brother is a commercial airline pilot. And just the image of Yuval in a pilot's uniform.
Yeah.
For whatever reason, just always makes me laugh. Yeah. It's totally unfair. And I have no idea if his brother looks like Yuval at all or anything like that. But I love the idea of like Yuval getting on the loudspeaker and being like, our flight time today is, I just think it's funny for some reason.
I think that's great. I think that has to be a future episode of The Remnant when you actually invite the brother on.
Oh, that's a great idea.
Yeah. And I think Yuval should issue announcements saying, we know you have a lot of options in choosing a think tank, and we're grateful for your choosing AEI today. Thanks for thinking with us.
All right. So let's start with things in the news type thing. Yeah. There was this hearing, circuit court hearing to hear Donald Trump's appeal of Judge Chutkin's ruling that Trump did not have blanket immunity to do whatever he wanted. And the thing that made all the headlines was, can the president order SEAL Team 6 to assassinate his political opponents?
Yeah.
And we got a remarkably reluctant, one might almost say concerningly nuanced response on all of that.
Yeah.
So big picture and small picture, what did you make of the whole thing?
Well, boy, I guess I'm relieved that they're thinking through their insanely broad arguments in advance. Uh-huh. Jonah, it's funny, actually, the argument, I haven't listened to it, just read the reports. But remember a few years ago, you and I used to bat around the line, the best way to take Trump isn't seriously or literally, but hypothetically. Uh-huh, uh-huh. And this seems the high watermark of that. And again, to be fair to Trump's counsel, it's not as though he walked into court and led with this. The judge asked the obvious sort of question, asking about the limiting principle of it all. Remember during the Obamacare litigation, we used to always talk about limiting principles and how far could the administration go in forcing us to eat broccoli or whatever. This is the obvious question. How far does the categorical immunity argument go? And like you said, at least they thought it through in advance. They did say there are bumpers on all of this. That's what the impeachment process is for. In a weird way, I almost kind of admire their confidence to go all in on the argument and say, yes, actually, the president could do this. I'm surprised that the lawyer...
Just to be clear, he says they could do it, but they'd have to impeach him first.
Have to impeach it first. That's right. That the president, meaning the president could claim immunity all the way through that until the point where he's impeached and removed. Mm-hmm. And in a way, I wonder if, because again, I haven't listened to the full argument yet, I wonder if counsel had an opportunity to maybe elaborate the point a little bit more and say, that it's implausible to think this would ever come up. Maybe ask, why would the president do this sort of thing? But to just go with it and say, oh, yeah, if that actually, in that nightmare scenario actually happened, we do have guardrails, their impeachment and removal, but not criminal prosecution. I think that's wrong, but at least they're making a logically consistent and coherent argument, not maybe coherent in other ways, but logically coherent.
So I have a lawyer friend. You'd like him. You might know him, but I don't want to out him here.
Okay.
But, I see him at the cigar shop often, and I often pick his brain.
Yeah, and lawyers are the best, so he's probably great.
And he said he had a good idea, tongue in cheek, but he was like, okay, if this is Trump's position, Biden should announce that pending this ruling, if it goes the way Trump wants, he'll give a standing order to SEAL Team 6 to assassinate Donald Trump. Which just sort of puts it a little bit in highlight, again, tongue in cheek, but like, this is one of these areas where I both admire you people with your fancy suits and belts and have real contempt for you people with your fancy suits and belts, because this whole idea of, are we really going to have this debate about whether or not the president can assassinate his political opponents? It gets into the law is an ass territory.
Yeah. And so first of all, Jonah, what do you mean, you people? Second of all, as you know, Tocqueville said a long, long time ago that even in the 1830s, scarcely a political issue arises that doesn't eventually become a lawsuit. And the problem with that is that legal argument is very different from political argument, and the constitutional arguments in lawsuits are just inherently different from the constitutional dialogue that we have as functioning human beings outside of court. And because these issues that we have now they all get channeled into lawsuits, and in many ways get channeled into lawsuits from the very outset, not in this case, but elsewhere, any political issue immediately becomes a lawsuit. It means that all of our constitutional dialogue in this country immediately gets channeled into legal style arguments, which are sweeping, categorical, pedantic, unrealistic. And there's a place for that. It's called court. And of course, again, that's where we are. We're here in court. But what worries me even more than the fact that these arguments are being made in court is that the rest of the country seems incapable of having constitutional arguments that aren't all filtered into litigation style legalisms. It's a problem when lawyers are making those arguments, but they're lawyers. It's a bigger problem when all the non-lawyers make arguments in that style. And the fact that all of us very quickly resort to legalistic style burdens of proofs and sweeping categorical arguments and assuming that everything has to follow to its logical conclusion, that in and of itself really deforms constitutional argument and debate in this country.
Yeah, I mean, one of the things I think is kind of amazing about this position that you cannot try a president for committing crimes, I mean, like serious crimes, unless you impeach and remove them first, is we also heard from Trump's lawyers in two impeachments, or particularly in the second impeachment, that first of all, you don't need to impeach him because he can face criminal legal penalties later. Yeah. And two, that you shouldn't impeach him when he only has days left on his presidency, because you can't impeach someone when they're not going to be in office anymore. And now, if we actually held to this theory that you can't try someone for crimes unless they're impeached and removed first, means that in the last week or so of a presidency, you can it can be like, Michael Corleone taking out all his enemies in Godfather, right? You can even kill a bunch of members of Congress so they can't get a quorum for impeachment. And like, that can't be the actual way our system is supposed to work.
No, it can't. And this brings us back to the theme we've touched on in the past about Republican virtue, and maybe we can delve into that. But I want to add one more argument one more question to your stack of contradictions here. It's one I've been thinking about this morning and thinking about these oral arguments. We have gone through now years of hearing debates about whether a president can pardon himself or not, right? The President Trump and his advocates arguing that, of course a president can pardon himself. And there's a serious constitutional argument in favor of that. It's funny how President Trump seems to think a president can self-pardon, but not, in a sense, self-prosecute. By the way, it works the other direction too. I wonder how many people who say a president cannot pardon himself also say that somehow he can't prosecute, his administration can't prosecute him. I'm not saying those two arguments are logically equivalent, but I do think it is interesting that we talk a lot about self-pardons, a lot about, in effect, self-prosecution. But some of those arguments have operated on parallel tracks without anybody maybe pointing from one track to the other.
Right. I mean, like, if Trump's position is that presidents basically can't commit crimes, why should the issue of self-pardoning even ever come up? Because,
exactly.
It's like the one hand clapping kind of thing. All right. So what is your actual position on immunity, official acts versus ministerial acts, or whatever, all this gobbledygook? This claim that if my memory is right, the claim that presidents are immune from criminal prosecution basically stems from the OLC rulings on civil lawsuits and stuff like that. It is not exactly like a settled constitutional principle, is it?
No, it's not. It's I think it's maybe at best implicit. Again, the president is the one who's there to take care the laws are faithfully executed. He has the executive power, not the Justice Department. The Justice Department, prosecutes on behalf of the president in a sense. And so in that sense, it makes sense that a president wouldn't be prosecuted. But there's no inherent constitutional rule against it. No it's at best implicit. Now, to your original question, what are the lines here? I think we all can say there's a core set of presidential powers where the president is operating as the executive. And for that, maybe it's good to have prudential rules against immunity, in favor of immunity, so that presidents can execute the laws faithfully in their best, they're in good faith, without having to worry that a future administration is going to turn a reasonable disagreement into a criminal prosecution. I get that. That makes sense. Also, I understand why courts might like immunity, because then they're not going to get sucked into litigation around what's essentially executive branch arguments from one administration to the next. I get that. And we all can understand that at the other end of the spectrum are times when a president isn't really operating as a president, but as a private citizen, as a political candidate. And in those, he absolutely should not get immunity. And we can even say somewhere in the middle, maybe the line is hard to draw. Maybe we should err on the side of immunity to avoid marginal lawsuits about these things. But looking at what President Trump did around January 6th, I think it requires a willing suspension of disbelief to say he was operating in any capacity other than Donald Trump candidate. And to the extent that he and his supporters say, well, he was actually trying to snoop out election fraud. I just think at this point, even then, but at this point, this requires a willing suspension of any reasonable disbelief.
I'm with you on this. I think there's a balancing test to be found somewhere in all of this stuff, right? And I get why you don't want presidents harassed with stupid. You don't want to do to presidents what they did to Tom DeLay, right? Where one county guy in Austin, district attorney, harassed him for 10 years, made his life miserable, and it was kind of a bogus thing. I'm not saying Tom DeLay was a great guy. I'm just saying you don't want that kind of stuff. But at the same time, trying to steal an election seems pretty much in the wheelhouse of the kinds of things that you shouldn't. I loved I don't know if you saw it, but in the Georgia case, Trump's lawyers said that he had not had fair warning that it was illegal to steal an election. And so therefore you cannot prosecute him for trying to steal an election because he just didn't know. And I guess this part of my problem with all of this is that I had this argument with my friend Charlie Cook back when Trump was contesting all of these elections. We're going to court constantly contesting all the stuff.
Yeah.
And Charlie, like a lot of people, had a very defensible position, which is you need to let the process play out. That was Liz Cheney's position prior to January 6th, is people let them have their day in court. That was Mitch McConnell's position, let them have their day in court and all that kind of stuff. But that doesn't work well in an absence of Republican virtue. If the lawyers working for Trump thought they actually had real facts on their side, that would be one thing. But they clearly were arguing in court for the publicity value outside the court to make it seem as if there was a real case. And that just feels unethical, and it feels like an example of the broader problem of our system being set up that assumes good faith by leaders, that they have patriotic deference to the good of the system that is just so utterly lacking in Trump world.
Yeah, and I can't help but point out they're making that argument outside of court and also outside of the Four Seasons Garden Center, which was very nice.
Yes.
Now, I will very gleefully point out that when all that litigation started right after the last election, I very much did not agree that we should all just wait for the process to play out. I wrote a piece for our friends at the Bulwark saying we just have to accept that President Trump will litigate this like a real estate bankruptcy, and he will reach for every argument like a broken beer bottle in a bar fight. And none of us should pretend that the process is going to play out in a healthy, legitimate way. And we learned the hard way.
So this gets to the ethics of some of this, and I find legal ethics weirdly fascinating and painful. Sort of like remember when you had a loose tooth and you just couldn't help but play with it, even though it hurt.
Yeah.
So this guy Sauer, I was listening. He was Trump's lawyer yesterday, who was giving the qualified, maybe yes kind of answer about assassinating your political opponents, and I was listening to the Lawfare podcast to prepare for this august conversation I'm having now. And there was a debate among their listeners and among their members about whether or not Sauer was doing good lawyering or not. And the argument broke down. I don't want to ascribe sides to it, but basically the argument broke down was he's making crazy, stupid arguments and he knows he's going to lose. That's bad lawyering. The other side was, no, actually, he's making arguments that trigger all sorts of delays in the process. And that's what Trump needs more than anything. That's what his client needs more than anything else, is delays in the process. And so making these bad arguments that will lose will extend the process. And he was doing the best job imaginable of defending bad positions. What say you about either of those?
John Sauer is a law school classmate of mine. He's a very, very smart lawyer. And I would be shocked if he was making arguments that he knew were losers for the sake of some sort of extra legal interests. I don't believe it. Who knows, but I don't believe it. I think he was taking the arguments at hand and making a logically coherent argument. And yes, to the extent the slippery slope of the argument is extremely disturbing, his argument was what it was. It was that we have all these other auxiliary precautions around prosecution to actually remedy that kind of situation. I don't agree with the argument, but I don't believe that John Sauer was like cynically making losing arguments for the sake of external political interests.
Well, I mean, I don't want to mischaracterize the criticism of him from other people, but like that's the way it sounded to me, was that the long-term legal strategy for Trump is to push back these trial dates till after the election, and then he can pardon himself, right? Yeah. And making this, I mean, like there's this, I can't remember which court. I can't remember if it was this one yesterday or the Georgia one, but there's also this argument that impeachment, since he was tried for impeachment, that trying him criminally would be double jeopardy.
Yeah,
which is the dumbest. I mean, like we've heard during all impeachments, people say, the president's not above law, it's not below law. This is a political process. This isn't a criminal trial. Blah 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 blah.
Yeah.
Now they want to say it's a criminal trial.
Yeah, absolutely. And I wrote about this at the time of the impeachments, that it's a great mistake to treat impeachment as a quasi-criminal process. It's not. It's more than normal, ordinary politics, but it's not a criminal process. And it's a mistake to try to confuse those things. You said a while ago, Jonah, you raised the sort of the ethical side of this, not just for the lawyers, but for the president. And I do want to circle back to that of course, our system presumes that ambitious politicians are going to push the boundaries of their power, and that ambition is going to counteract ambition. And that's why we have a separation of powers, and we don't assume that all men in government are angels and so on. But I think the point we've reached now just reflects the danger of reading those parts of Madison and the Federalist, but not all the other parts, where they really did worry about Republican virtue, or maybe not worry, but they made both explicit and implicit that the system in all three branches of it really depended first and foremost on certain virtues. It might be different from one branch to the next, but each branch for its own operation requires certain virtues, and you need that in the people themselves. And yeah, it might ebb and flow in certain places and certain times, but you need it somewhere to sort of counteract the others. And our system doesn't actually work when it is just a hellscape of all against all, without any kind of self-restraint and a treating of government power simply as power and not as a burden or responsibility by the one wielding that power. And here we are.
Yeah, so I'm fairly confident that you would not be game to take Trump on as a client in all of this, right?
No.
And I understand everyone has the right to counsel, but they don't have the right to a specific lawyer, right?
Yeah.
And that's why I brought up the original disputes, the election disputes that Trump brought, after the election, where I was reading Liz Cheney's book, and Mike Johnson was making factual misrepresentations to the court in the amicus brief about the Texas dispute. And it just seems to me that there should be more ethical sanction for lawyers who are technically, they're not breaking the law, but they are defending someone who is deliberately exploiting the good faith of the system that the system relies upon in bad faith. And I know no one's going to listen to me on this, but that's just sort of how I feel about it.
Well, if you think that I'm going to start knocking my lawyer friends, you've clearly never heard of honor among thieves. So let me just say that up front. Again, there are easy cases, there are hard cases, and in the middle, we probably should err on the side of letting lawyers make the most aggressive arguments possible in defense of their clients. And that's just a fundamental principle of our legal system. That's right. And so I don't like it when lawyers get sanctioned on political grounds. Of course, there's now the prosecution of John Eastman and others, which I put in a different category, where they did simply cross the line. But no, I think we should be glad that lawyers are willing to make strong arguments and every available reasonable argument, and even the long shot ones. But I do worry that, again, when all political issues become litigation, and everybody is filing briefs and they're filing them in a hurry, the quality of legal argument in these briefs, it's hard for me to imagine it just not going down as everything becomes that much more cavalier. I don't know. I don't litigate anymore. I don't read nearly as many legal briefs as I used to. But I'm not surprised that mistakes slip into these briefs.
So let's broaden out for a second. There's a robust debate that I am squarely in the middle of. I'm saying I'm not in the middle of people influential in the debate. I mean, I have sympathy for both sides about whether or not the Section 3 of the 14th Amendment can be invoked to prohibit Donald Trump from being on the ballot, that it is self-executing. I found to the extent I could understand all the big words, the William Bode, Paul Stokes law review piece on this, pretty persuasive. I thought David French did an admirable job on the New York Times the other day on this. At the same time, I don't really believe that politically or even constitutionally self-enforcing is a thing in the way that people need it to be for this thing. So where do you come down on it?
I might be misremembering, but I think a couple of years ago I was on the show and I referred to January 6th as an insurrection. And I think I might be misremembering, but I think I did. And I think you might have said, well, wait a second, maybe we shouldn't jump into that word. And I said, well, it might mean different things in different places. But I'm not afraid at all to use the word insurrection. I think it was more than just a riot. So that let me just start with that.
Okay.
But then when it comes to the 14th Amendment and actually litigating it in court, I become very, very skeptical or wary. And this gets back to my point about taking constitutional argument and immediately filtering it into lawsuits and litigation and legalisms. Because it's one thing for me as a voter to ask myself, can I vote for this candidate? I think he or she engaged in insurrection or gave aid or comfort to an insurrection. That's what, and I think actually, sadly, all citizens now have to at least ask themselves that question. It's quite another thing, though, to say that the meaning of the word insurrection is so clear in the Constitution, and that what happened, as a matter of fact, is so clearly an insurrection within the meaning of the 14th Amendment, and that what President Trump did in his words is so clearly giving aid and comfort to an insurrection that a Secretary of State or a state Supreme Court or the U.S. Supreme Court can take a presidential candidate off a ballot or declare him ineligible to be president. It's that extra step where I get off the bus. Will Bode, a friend of mine, great lawyer, great legal thinker. We've spent a lot of time debating other issues over the years. And Michael Stokes-Paulson, also great legal scholar. I just don't agree with them that the words so clearly mean what they mean, or what Bode and Paulson say they mean, that it clearly points to an easy solution here, an easy judicial solution. But let me just add to that because we're now arguing all of this in terms of what should the courts do? Is it anti-democratic for the courts to declare Trump ineligible? That I feel like the public is in a way sidestepping the harder issue, which is what's the duty of a citizen,
right?
And how should we bring this issue alongside others in trying to decide ultimately who to cast a ballot for? I mean, again, to invoke our boss Yuval Levin, the question, even though the constitutional words are the same, the question and the task at hand is different for a court versus an executive versus a legislature versus a voter. And we shouldn't mistake the litigation version of this debate for the version that we all should be asking ourselves.
Let me first back up and just say, look, I agree with you. I think part of the problem is it's one of these really terrible catch-22s where if we had the right citizen, if the citizenry had the right reaction to January 6th, it wouldn't get to the courts in the first place because he would go, his candidacy would go nowhere, right? It would people would just be, the party wouldn't let him on the ballot, voters wouldn't give him the time of day, but because you have the populism problem, it gets pushed into the court. So I agree with that.
Wait, let me cut you off there. Hold on a second. Like I said, I think it was clearly an insurrection, and I would vote accordingly. Another part of the job for us as citizens is to accept that even thinking about it non-legalistically, it's still a hard legal and factual question. And so it might not be that the right answer is for the public to disavow Trump as a candidate on the basis of the 14th Amendment. Maybe that wasn't what you're saying, but
no, that's not really my point. My point is like, if let's just put it this way. If the revulsion that rank and file Republicans and Republican leaders had to January 6th, that they had on January 6th, on January 7th, and January 8th, had not dissipated, it wouldn't matter whether it was an insurrection or not, because whatever it passed that legal or constitutional threshold question, it passed the threshold question of it was really bad. And that should be enough, right? He's a sore loser. He didn't win. He lied about the election being stolen. That should be it, right? And so it shouldn't have to get to these angels on the head of the pin thing about Section 3 and all of that. But when you say anti-democratic, I just want to push back a little bit. First, why should I give a rat's ass if the Supreme Court does something that's, I would say, non-democratic, right, or undemocratic? The courts are supposed to be non-democratic in very fundamental kinds of ways, and they do non-democratic things all the friggin' time. Now, you can make a case that they're actually, by keeping this guy off the ballot, they would be working to help democracy. But that gets into punditry, right? I just mean, like, as a matter of first principles, you can't say, well, this decision from the Supreme Court is undemocratic and therefore wrong, because we want it to be undemocratic all the time.
Correct. And you could even, surely some argue that the 14th Amendment itself is the product of democracy, and therefore to uphold the 14th Amendment here is as they see it, is itself pro-democracy. I totally get that. There's all kinds of pro-democratic arguments in favor of declaring President Trump disqualified. All I'm saying is that so often, not all the time, but so often, the Supreme Court's mistakes and oversteps and overreaches have come when it took vague constitutional text and suddenly enforced it in a very specific way to take choices away from the more democratically accountable parts of government. We saw that the whole history of the 14th Amendment for the last century has been courts invoking the 14th Amendment to take issues away from Congress or away from state legislatures, and so on. And so all I'm saying is that, and I don't think this is particularly controversial, but to summarily declare a presidential candidate, I guess the leading presidential candidate, ineligible for the ballot on heavily contested grounds would be, in at least one major sense, anti-democratic, in the sense that it would take away from the voters the power to choose. In a way, it would relieve the voters of their duty to actually choose and make the right choice. And that's all I'm saying is, in that sense, it's anti-democratic.
Yeah,
I don't think that's the end. I don't think that's the end all be all. We shouldn't ask ourselves, well, what's the democratic outcome and follow? We should ask two questions. One, what does the 14th Amendment mean as best as we can tell? And two, what's the role of the court in deciding a case under the 14th Amendment in light of either clear or vague legal language? That's the hard question. Not to go all Alexander Hamilton on you, but in Federalist 78, where Hamilton sketches out judicial review and says, of course, if a statute violates the Constitution, then the Constitution stands and the law must fall. But then he goes on to explain that, you're going to have to ask yourself, what's a reasonable way to read the statute? Can you keep it? If you read it one way, will you save it from unconstitutionality? Can you do that reasonably? Is there any way to reconcile these things? What he was saying was, in the case of judicial review of statutes, the hardest choices judges have to make are not constitutional or unconstitutional, but questions of reasonableness in the middle of that. Am I being unreasonable in too narrowly or too broadly reading a statute? That's the hardest choices a judge has to make, even in ordinary cases. And obviously this is not a case of striking down a statute, but again, the court has to ask themselves, each justice has to ask himself or herself, what do I think the 14th Amendment means? What do I think the facts at hand are? And in light of that and my certainty or lack of certainty, how do I then decide a case that's going to have these significant effects of taking somebody off of a ballot?
All right, since you kind of teed it up pretty well for me here. Part of your day job is being like Supreme Court watcher, Supreme Court explainer, Supreme Court whisperer.
Yeah.
And my impression from talking to legal type people is that Justice Roberts would very much like the Trump era to go away. Which does not mean he's going to rule specifically one way or another way, because that's just not how it necessarily does work or should work. But how do you think the Supreme Court, and then we'll get to the broader, just sort of the court in general, but how do you think the Supreme Court, when it inevitably gets both the 14th Amendment stuff, but also the immunity stuff, how do you think it's going to go?
I found in this town the easiest and fastest way to alienate all my friends and enemies is to say something nice about Chief Justice John Roberts. It's the one thing that everybody seems to agree on, is that he's like a cynical, tactical politician. And I tend not to agree with that. I tend to take him at face value, and I like a lot of his work. There's the happy accident that this case, the 14th Amendment case, might get to the Supreme Court right around the same time as the immunity issues.
Yeah.
And as we've described, I think the arguments for the court disclaiming presidential immunity here seem pretty strong. the arguments, as I see it, the arguments for the court not embracing the 14th Amendment argument here are also pretty strong. So we might wind up with the court deciding those cases on the same day or close to them, and one cuts in Trump's favor on the 14th Amendment, one cuts against Trump on immunity, and that would be like a nice, happy conclusion. I don't think any of the justices are seeing it in those terms, although obviously they're aware of the context. I think my sense of my instincts about the justices is that a majority of them will be skeptical of the 14th Amendment argument for the same reason that I'm skeptical of it. But again, that's, I guess, awfully convenient to assume that the justices will wind up where I am on it. But so far, I do think that seems the most likely outcome on the 14th Amendment, given the justices, their temperaments, their writings, that they're going to be wary of ascribing this much certainty to that 14th Amendment provision in this case. So I'll be surprised if the justices uphold the 14th Amendment argument out of Colorado. I'll also be surprised, to say the least, if they embrace President Trump's theory of immunity, or even any theory of presidential immunity that actually reaches what President Trump did here.
Yeah. I mean, so I know court watchers assiduously deny that, and the court itself denies that vote trading happens or any of that kind of stuff, right?
Yeah.
And I'm inclined to believe that's true as a matter of explicit, I'll give you this vote if you give me that vote. I'm very skeptical that kind of thing happens at all. Mm-hmm. At the same time, I know we don't want Supreme Court justices or chief justices to be politicians and whatnot. But you can see, given the historic nature of all of this, an institutionalist's argument for Roberts to do all he could to get 9-0 on against the immunity stuff and 9-0 against the 14th Amendment stuff. And that would not bother me. Like, that seems to me to be a responsible statesman-like thing to try to do, as long as you do it within the guardrails, right? I mean, you can't just, it has to be a defensible position for everybody. Yeah. Do you disagree with that? Or is that, I mean, like, are you not allowed to say that because you'll get kicked out of all the right clubs about how, it has to be, let justice prevail, though the heavens may fall?
Yeah. Maybe, Jonah, for this, it's more important not to be a court watcher, but a court litigator watcher. It all depends on how broadly the lawyers stake their claims in these cases. And they might do the justices a favor. If President Trump marches into court with this extremely broad version of immunity, he might well succeed in getting 9 justices to rule against him. Mm-hmm. Same thing with the Colorado decision. To what I've seen so far out of the Colorado opinion and the arguments around it, they have a extremely broad and malleable view of the 14th Amendment that anybody can see would create just a hellscape of future litigation around alleged insurrections. Hard to imagine anything approaching January 6th, but you're already seeing arguments that, what's happening at the border is an insurrection. And, people argue that the Black Lives Matter protests and when they got violent were an insurrection. And so if the defenders of the Colorado decision make their arguments as sweepingly and as malleably as they have so far, they might well get a 9-0 decision. And when the litigants do make arguments that broad, they make the Chief Justice's job easier in being able to write an opinion that can attack a very narrow issue, categorical immunity, broad view of the 14th Amendment, and reject it and then move on. And so the litigants themselves might make Chief Justice Roberts' job a lot easier.
Kevin Williamson still had the best line about the difference between the Black Lives Matter riots and the January 6th riot. He says, there's just a big difference between a coup d'etat and a coup de target.
Yeah.
But, all right.
Hey, one more thing on this, by the way. I seem to recall, I could be wrong, but in thinking about insurrection, I'm pretty sure that when Jefferson Davis wrote his memoir after the Civil War, that he devoted a pretty significant chunk of it, maybe even a chapter, to arguing why the Civil War was not itself an insurrection. Of course, he had to put that in the book, if I'm remembering correctly, because he had to. Everybody knew it was an insurrection. Right. You could write the 14th Amendment in its own time and know exactly what we're talking about. But then to let 150 years pass, we ought to be a little bit have a little bit of humility in our confidence about what exactly it means as a matter of principle and as a matter of fact.
Yeah, I mean that cuts both ways, I think, because on the one hand, you know, the people who say, "Oh, you need a judicial process, you need due process to decide whether someone's an insurrectionist." Well, they didn't after the Civil War. It was like if you were a member of the Confederate Army, you were an insurrectionist, and so like they didn't have trials for each person. That was part of the reason they put that thing in the 14th Amendment in the first place.
Yeah.
On the flip side, it was really easy to tell who the insurrectionists were because they wore the uniform, right?
Yeah.
And so it kind of cuts both ways. But I don't think you need due process to say someone's an insurrectionist.
Yeah.
But you need some other really glaringly obvious indicia, as you people might say, that that tips the game off, and that's sort of where this gets messy.
I mean, it is called the rebel yell. I mean, it's right there in the name. We don't need to dwell on it, but I just want to say the question about whether the president is an officer within the meaning of the 14th Amendment, that's actually a serious legal argument. It's much more, I think it's actually a much more serious legal argument than we might think at first instinct. Like in one sense, of course, the president is an officer, but in the context of the 14th Amendment, the way it's written, the way it's structured, that's actually a very interesting argument. And Professor Kevin Lash, another great scholar of the 14th Amendment, has an interesting article about this. I think he might have turned it into a New York Times op-ed recently.
Yeah, David mentions it in his defense of the taking them off the ballot thing.
Yep.
And this is borrowing a schema from Sarah, but like my position on this is like I have very little patience for people who have like, I shouldn't say little patience because a lot of them are my friends. I have very little patience for the argument that it's just transparently obvious that this 14th Amendment thing is dumb and stupid and outrageous. And I have very little patience for the argument that it's a slam dunk, totally persuasive on every count. Although I got to say, David's case was pretty good. But because to me, and this is this point that Sarah made, it's like a lot of things in legal stuff. You have this checklist of criteria. And okay, so it's this one with 52% of the, and this one it's right, but just over the line. And then you add them all up and it really doesn't feel like this overwhelming case because each subsidiary point, you barely won the argument on it. And the other side had a good counter argument. And so like, I think on the officer thing, it came up in the debates about the 14th Amendment and the guys who were debating it said it covered the president. That seems a useful data point. But I'm with you. We shouldn't be having the friggin' argument is the real point.
Yeah. And just at risk of repeating myself one more time, as we're all talking about what the court should do, and what I get impatient with is all of us sort of assuming this is the only argument. And, once the court issues its decision, we can all sort of, wash our hands of it. And incidentally, by the way, I hope everybody likes their 14th Amendment arguments because regardless of what the Roberts Court actually decides, if President Trump wins election to be once again President Trump, we're going to spend all of December next year listening to arguments about whether the Congress has an independent duty. Each member of Congress has an independent duty separate from the Supreme Court to refuse to count an electoral vote for President Trump because he's ineligible. I mean, the arguments we're having around the Supreme Court, they're bad. They're hard and often ugly in so many ways. But if Trump just wins outright in November, we're going to have a very different institutional argument about the exact same issue.
Interesting point. It's also, even if the court rules that he's ineligible to be on the ballot or that states can take him off the ballot, they can say, I don't think anyone will buy it, but they can say, well, Congress can, according to the Constitution, can also lift that insurrection title and make them viable again. And so then passing a buck back to Congress, you have to do it by 2/3. So it's very unlikely that would happen. But anyway, it's interesting. All right. So overall, how do you think the court's doing?
What do you mean?
I think it's fair to say that Justice Roberts really wanted to sort of help restore the stature of the court, the legitimacy of the court. He wanted a lot more unanimous decisions rather than divided decisions. It was sort of like Bush v. Gore was this, not necessarily a stain, but it was this political albatross in a lot of ways for the court because it eroded faith and trust in the Supreme Court. And it seems like he's had his work cut out for him, and that some might even say that he hasn't fully succeeded in his ambitions.
Yeah.
So when we start there.
Yeah, well, the court's approval ratings, so to speak, are, I guess, at a low, maybe an all-time low. I tend to think that's just a fact. That reflects not just a lot of the public dissatisfied with the outcomes of the cases, but also the fact that the Supreme Court's in the news probably doesn't do it a whole lot of good in general. The Supreme Court's probably most popular when nobody's thinking about it. So, like we said before, we shouldn't worry about the court being anti-democratic. We shouldn't worry about the court's approval ratings. But I think the point's well taken that when Roberts came to office in 2005, his goal was to restore public trust in the court, or to help build public trust in the court by making the court more unanimous and less interesting. And to quote Shakespeare, some men are born great and some have greatness thrust upon them. And here we are with the court having over and over again things thrust upon it. The court doesn't seek these cases out, but they land there. And they land there ever more quickly because the parts of government that make policy ever faster. The administrative state, governors, presidents, district judges often. So the court, I think, has its work cut out for it, separate from anything it does. The court is just more quickly embroiled in political controversy. Maybe there's some things the court could do to sort of adjust to the current environment. I was on the President Biden's court packing commission, so to speak, and so I spent a lot of time thinking about this, I guess. I think it is interesting to see the court recalibrating a bit. They last year started hearing cases a bit more quickly, but with less use of the shadow docket in some cases. I think that was an interesting adjustment. The justices, I don't keep track of these things, but I get the sense they are giving less public talks than they used to. Maybe that'll help. I don't know. I actually kind of wish that justices would keep talking in public, but would speak more to audiences that aren't sort of identified as their side. Maybe Elena Kagan speaking to the Federal Society, and Justice Thomas speaking to the American Bar Association. They don't, and that maybe says as much about audiences as it does about the justices. But I think it would be good for the justices to continue to try to engage the public in healthy ways. I feel like that didn't actually answer your question, but
no, that's
right. Where I did.
Yeah. So let me ask you, come at this from a different direction. So, and not about the court, but a different thing that I'm sort of fascinated by. So this is going to veer slightly into punditry, but I think you can handle it. Yeah. So harken back to 2015, 2016. The argument from a lot of leading conservative institutions and organizations and conservatives themselves, was Trump's imperfect. He's the lesser of two evils. It's a transactional thing. The most symbolic thing in all of this, I mean, the sort of quintessential example of this was his lists of who he was going to appoint on the court, because conservatives didn't trust him. Right. And so he consulted with the Federal Society, with the Heritage Foundation, before the fall, and got lists that we could all get excited about, right? And he basically stuck to the lists, right? At least on the Supreme Court. Yeah. And what has happened to a zillion other institutions is that they are facing the problem of Trump has basically converted their rank and file to be their first loyalties to him rather than to the organization. And so like you can see it in the evangelical Christian world, not to say that all evangelical Christians are Trumpists now, but lots of institutions have to be, this is what Tim Alberta's book is basically all about, is a lot of these institutions have to be Trumpy because the people in the pews want them to be Trumpy. The Heritage Foundation has gone Trumpy because its donors, its mass base of donors want it to be Trumpy. Fox obviously had these kinds of problems. Now, the pro-life movement is struggling with this problem because, Trump is basically saying things that 5 years ago would have cost him vast numbers of pro-life voters. We can negotiate something that the these state bills that have cutoffs at 8 weeks or 14 weeks. They're outrageous, blah, 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 blah. We can cut a deal. And now you have people leaking to the New York Times, saying to the New York Times that the next Trump administration won't want any Federalist Society people because they don't know what time it is. They want strong, manly, strong like bull lawyers who will do whatever is required. And you can see them every day auditioning on Twitter.
Yeah.
About, how many people they're going to round up or whatever. Yeah. So are you at all worried that the Federalist Society's clout, the conservative legal movement's clout, is threatened by this same sort of dynamic? Because it used to be the Federalist Society was synonymous with the right kind of judges.
Yeah.
And now the Federalist Society is seen as insufficiently loyal to Trump because too many of his lawyers wouldn't break the law, and too many of these judges he appointed wouldn't go along with his nonsense. And so now they want a different kind of lawyer, a more pragmatic lawyer, let's say. What do you think the future of the conservative legal movement is, given this dynamic that I've taken a long time to spell out?
Yeah. There were interesting fault lines within the conservative legal movement intellectually, even before Trump.
Sure.
Right. You had the libertarians arguing that judges should go a lot farther than traditionally conservatives had called for. And now we've got the weird Catholic integralist arguments, and I'm Catholic myself, so I can say that. There were going to be interesting, I think, more brutal disagreements within the conservative legal movement, regardless of Trump. Trump, of course, introduced all the prudential judgments about what somebody should say if they want to be in an administration, if they want to be in a political movement. I honestly don't think Trump and MAGA are going to derail the Federalist Society. I think the Federalist Society's main audiences have always been judges and lawyers, and that conversation is going to continue. But I do agree that the sort of the steady pipeline from the Federal Society membership to Republican administrations wouldn't be nearly what it is in a Trump administration. I don't see the Trump legal arguments really changing the ideas in the Federalist Society. I don't think the Federal Society, like your average Federal Society speaker, is becoming like Trumpier intellectually. I just think that conservative lawyers in the Trump era had to be, more careful about what they were willing to say out loud if they wanted to go into an administration. That meant, by the way, that some great lawyers got into the administration and did a lot of good. It also meant that good lawyers didn't stand up and say important things when they needed to.
All right. So the scenario that I worry about, right, is that there's this assumption that, and we see it all over the place in the Republican Party, all over the place in MAGA world, right? I mean, this is like, we now see the House Freedom Caucus furious at Speaker Johnson because Speaker Johnson didn't have the intestinal fortitude and sheer Green Lantern willpower to force Chuck Schumer to agree to the budget that the House Freedom Caucus wanted, and therefore he's a cuck rhino squish who lacks the spine, the Stalin-like spine that would achieve all the victories that could be achieved if only men of strength were in that position. And there's a similar argument in this sort of we need lawyers who know what time it is thing. Mm-hmm. There's this like assumption that it was the milk toasty cowardice of these Federal Society guys to not swing for the fences on things like the Muslim ban or the wall or whatever, when in reality, the fact that these guys wouldn't make the arguments that Trump wanted was a sign that they were good lawyers because they knew they would lose in court.
Yeah.
And so the scenario that I worry about is you're going to get, these Pam Biondi, Tom Fitton approved hacks who are going to staff a Trump administration, and they don't mind losing in court because it's the new front in saying, see, the system is rigged against us. It's the deep states, these deep state judges. We don't need to pay attention to these courts. They're not trying to make America great again. And for them, it's win-win. If they win at court with garbage, it's a success. If they lose a court, it shows how the system is rigged against people who actually love this country. And we're going to see a new front open up in the undermining of important institutions. Is there a more rosy scenario to be found in there?
No, not really. And I think it's a lot like how once upon a time being held in contempt by Congress used to be a bad thing, and now it's like the best thing that can happen to you.
Right.
So you can stand up and say, "Well, I hold this Congress in contempt, and so should you." I think there's a lot to that for a lot of this, the arguments are not really about winning or losing in court. They're ultimately winning and losing power and power politics. And losing can be, in one form, can be a source of strength. So I agree with you. It's only going to get worse. I do worry about who will be the lawyers in a future Trump administration.
Well, they're mostly going to be acting because very few are going to get approved from, the Senate. All right. Well, is there anything we missed that you feel a burning desire to get out there and set the record straight on?
Well, this is also cheerful. It's how could one not end it here? But I'll just say, I wrote a piece for the Dispatch at the end of last term, thinking about the Harvard case and a few other things, and thinking about the path forward. And I think since we're talking about the conservative legal movement, conservative legal ideas, I just want to reiterate, this is a moment where the court in some ways closed one chapter and opened another, right? The Dobbs case on abortion, the Harvard case on affirmative action, those were the culmination of decades of debate, and they were like the two main issues that gave rise to the conservative legal movement. We should, and those issues will continue, of course, and we're going to have affirmative action cases involving employers, and we're going to have abortion cases involving the FDA and emergency abortions and so on. But I tend to think of this as a moment where the real task before the Roberts Court and the Supreme Court after Roberts is grappling with new issues. Or radically different versions of old issues. Now, I tend to obsess over this in issues around the administrative state, where after 75 years of the growth of administration, you now see agencies like the Federal Trade Commission or the financial regulators really staking out new or different powers, new or different tactics in a way that raise just totally new questions for the court. And we're seeing that around the social media cases and so on. I have to admit, if I thought the future was going to be another 25 years of just the same constitutional issues over and over again, even I would start to get a little bored. Mm-hmm. But I'm just endlessly fascinated by the way in which these new issues are arising, just the practicalities of government, what governors, agencies, and district judges are doing really is in many ways unprecedented, and is going to put all kinds of new challenges before the Supreme Court. And I'm very curious to see how the justices' instincts and temperaments will translate into decisions in the future. I think it's going to be extremely interesting. And also, I think I mentioned Justice Kagan earlier in passing. She's the first progressive justice, the first Democratic appointed justice who really speaks textualist as a first language. Mm-hmm. And so she is driving the conservative justices to have to be more precise in exactly what they're saying, which is going to open up interesting disagreements among the conservative justices too. And so I find this very, very interesting. It's all, I think, downstream of what's happening in actual politics and government. It's not the Supreme Court picking these fights, no matter what Senator Whitehouse or other people say, but it's the court having to really grapple with fast changing and fundamentally changing styles of government in this country. And so the next few years of this court are going to be extremely interesting, and they're going to be on issues that either we haven't thought as much about or haven't even occurred to us yet. I mean, it's too bad. I mean, I guess some of the issues have never occurred to us before because we never had to think about whether something was an insurrection or not, and so on. But we should think of ourselves as in a new chapter of the American legal constitutional debate.
Okay, so that prompts just two questions for me. One is Mike Gallagher, Congressman Mike Gallagher.
Yeah,
he and I had discussed favorably the idea of acquiring Greenland a long time ago on this podcast.
Oh, I was in favor of it too before you guys did it on the show.
And so the thing is, once it became Trump's idea, it doomed the already improbable chances of acquiring Greenland because it made it seem like more harebrained thing than it actually is.
Yeah.
I wonder, when Steve Bannon at that first post-election CPAC said that his main target in the Trump administration is going to be dismantling the administrative state.
Yep.
For someone like you, who has been sort of dedicated to, you're sort of like John Winger in Stripes, talking about how one of these days Tito Puente is going to die, and you're going to say, I've been listening to him all these years, and I love his stuff. You've been talking about the administration state. It's been your white whale for a very long time.
Yeah.
Did the Trump administration's at least rhetorical adoption of declaring war on the administrative state make your life easier or harder?
Well, made it harder in some ways, especially around the civil service reforms, where now we can't debate whether to reform civil service without it devolving into a question about Schedule F executive order, and is President Trump trying to gut all of government just to kill it? So that definitely makes the arguments, the debates harder. I should say, by the way, the Trump administration did some great things on regulatory reform, and I like all of those. But I'd say the Bannon quote was in some ways very useful to me because it just missed the point. The point is not deconstruction. The point is construction or reconstruction. The conservatives' greatest achievements in regulatory reform have never been in tearing down things that existed, but in building up things like OIRA in the White House to be like the cost-benefit check and balance on agencies. And conservatives who want regulatory reform need to think in terms of construction, not deconstruction. New institutions, new rules, new norms, new laws. And so in some ways, Bannon making that point did me a favor because I've been able to sort of tut the terminology ever since. But beyond that, yeah, it is unfortunate that so much of what President Trump did or said and what his team did and said sort of preemptively discredits a lot of ideas in the eyes of people who aren't following everything closely. Right. And I just say, by the way, whether it's regulatory reform or the courts, and get back to the court one last time, my problem is not with the American people disagreeing with the court without reading the court's decisions. Thank God we live in a country where not everybody has to be a lawyer and a law professor. And I don't think it's an answer to say, oh, you don't like Dobbs? Well, if you haven't read the decision, you're not allowed to disagree with Dobbs. No, voters are allowed to vote and to draw conclusions without having to be experts. The fault that I really see is the institutions right around the court and right around, say, the White House and so on, where law professors, journalists, and others, they're the ones who have fallen down on their job of really trying to explain what's happening in these legal cases, and I think in a neutral and reasonable way. And same with the debates around Trump and the Trump White House. It's the folks who are supposed to be watching these things closely and speaking up. They're the ones who we should all hold responsible when the public doesn't, in our view, really understand what's happening. I don't blame voters at all. They don't need to be law professors. Thank God. I mean, there's already enough of those.
One of the great examples, for reasons of self-harm, I watch MSNBC a lot, and the number of people who say, well, Trump has 3 appointees on that court and they're going to be loyalists or whatever, or imply it. It's so contrary to the actual historical record of where most of Trump's appointees on the Supreme Court and also on the lower courts, they have not been water carriers for Trump, but it's just this glib, easy kind of shot to take. All right, but last question.
Yep.
When you were talking about Kagan and textualism and whatnot, this is something that has been bothering me ever since those frauds and advisory opinions discussed it a while back. The phrase is history, text, and tradition, right? That's like sort of the originalist approach.
Yeah, text, history, and tradition.
All right, text, history, and tradition. What is tradition doing there that history isn't, or vice versa? What isn't it a little redundant? If it's not history, then it's not tradition, and if it's not tradition, it's not history. So what is a glaring example that distinguishes history from tradition in an analytical mode? And it's been bothering me because I think it's a really good question.
That is a great question. And you know who's great on this actually is our AEI colleagues, Joel Alsea and Will Hahn. So they'd answer better than me. Now you've all be pleased with me because I plugged our colleagues. But I'd say, yeah, there's obviously a lot of overlap. But I think when people talk about text, history, and tradition, the history they're talking about is like the history of history books, like the narrative account of how things happen and why. Tradition, I'd say, is something less analytical. Tradition is the more Burkean or Bekelian explanation of things that we have now that we've had for a long time that we can't necessarily rationalize or explain, and we don't feel the need to, right? It's things that have practices that have been around for a long time. And when people talk about text, history, and tradition, they're saying, what does the law mean? Why was the law written the way it is? And to what extent does our reading of the law comport with or conflict with the actual traditional practices of the American people?
I like that answer because, whenever you say Burkean, I like Burkean, but when you actually look at the specific cases, it becomes very difficult to say, like, then put it this way. It's very difficult to find, in my conversations with people, an example where history and tradition are in conflict with each other.
Yeah.
Right. And so it becomes this, but then again, there's a long tradition of using tradition in this list. Yeah. So maybe we'll just keep it.
Well, and here's an example. In the First Amendment context, can a legislative body have a prayer before the city council meeting or something, or a prayer before high school graduation? Text would be the First Amendment. What does the words of the First Amendment, the establishment of religion, the free exercise of religion, what does that actually mean? History might be, what's the history predating that amendment? Why did they write the amendment the way they did? What's the case law since then? Tradition really sets aside those first two things and says, what has been the American tradition, the practice, whether we talked about it in First Amendment terms or not, how have we actually lived our lives? And then when you bring it back to text and history, you say, here's what I think the text means. How confident am I in that? And to what extent would my reading of the text throw out a long-standing tradition of American life? I think that's what the folks mean when they say text, history, and tradition.
All right. To be continued.
To be continued.
Adam White, there's no truth to the rumors that your parents were huge Tolkien fans and your middle name is The. But it's great to have you on, and I hope you'll come back. And I hope you'll write more for the Dispatch. When I told people on Slack today that I was going to be talking to you, several editors were like, tell them to stop turning us down.
No, I don't recall hearing from them. I don't know what they're talking about.
Lies. You sit on a throne of lies. Adam White, thank you so much for doing this.
You bet.